2013 Chloro Controls in 2013 and Kieran Properties case in 2018 closely align with decisions of Australian courts in the interpretation both of the International Convention and the Insta-Trial Model Law as municipally implemented. And the assent given in August of this year by the Parliament of India to amendments to the Indian Arbitration and Conciliation Act of 1996 and the proposed creation of an Arbitration Council of India and an independent New Delhi International Arbitration Centre based on the recommendations of the Sri Krishna Committee highlights the importance which the Government of India places on international commercial dispute resolution. That is a natural concomitant of a dynamic, liberalised modern economy. But returning for a moment to aspects of the overlap at a professional level between Australia and India, there are many lawyers of Indian ethnicity practising in Australia, including at very senior levels, both at the Australian Independent Bar as well as in leading law firms. They form part of a significant Indian diaspora in Australia, estimated at nearly 750,000 people, a number which has doubled in the last 10 years, and that has implications for increasing economic as well as personal ties between the two countries. There are also, as some of you might know, a very large number of Indian students studying or who've recently studied in Australia. According to one source, 4 of the top law schools in the world are in Australia, and last year over 75,000 Indian students enrolled at Australian tertiary institutions. A good number of those would have been lawyers. Again, that has implications for the developing ties, including legal ties, between our two countries going forward. So the common features of our legal systems and ongoing and increasing connection through legal education bear upon what I wish to say this morning. The subject is really international commercial dispute resolution from an Australian perspective, but with an emphasis on an Australian perspective, but with Indian commerce and Indian law in mind. And by international commercial dispute resolution, I don't just mean international commercial arbitration, as I shall explain, and as important a topic as that is. Let me just touch a little bit more on the economic ties between our two nations before expanding. India is Australia's 5th largest export market and 5th largest two-way trading partner. Two-way trades in goods and services has grown in value from $13.5 billion in 2007 to $30 billion in 2018, so very rapid growth. Australia has an official government Indian strategy, an ambitious vision for bilateral trade to be developed over the next 15 years in a report which was formally endorsed by the Australian government, and consistent with that, our Prime Minister will be visiting India, New Delhi early next year, and only last week a former Australian Prime Minister spoke here in Delhi at the India Foundation urging greater ties between the two countries. Reflective of Indian investment in Australia, particularly in relation to coal and other minerals, in recent years, Australian courts have entertained a number of high-profile disputes involving Indian companies, and I was a participant as senior counsel in a number of those matters. Unsurprisingly, many of them concern the resources sector, in particular coal, natural gas and steel making. One involved an Indian company's investment in a coal mine in Western Australia, one the construction of an oil and gas platform off the coast of India managed by an Australian company for Oil and Natural Gas Company of India, and another related to investments in a coal mine in Queensland, which is a large state in Australia rich in resources. Obviously enough, in transnational commercial disputes, the disputing parties will often be parties to contracts which contain their own built-in dispute resolution clauses. They may nominate arbitration and depending on the level of detail, a seat of the arbitration and a set of arbitral rules by reference to which a dispute is to be administered and ultimately resolved. Other contracts may include not an arbitration clause, but a court clause, a forum or a jurisdiction clause, nominating the courts of a particular country, state or province for the location for dispute resolution. Sometimes the nominated court will be that of one of the contracting parties, but often it will be a neutral forum. And with the Indian economy growing at a quicker rate than almost any other country in the world, trade being liberalised and foreign investment in India being encouraged by the Modi government, Indian companies will become increasingly party to more and more contracts with the transnational character, or because the contracts will be between companies from different countries. With that in mind, and with a time difference of only 4 hours between, say, Delhi and the west coast of Australia, Perth, 6 hours from the east coast, so that's Sydney, Melbourne and Brisbane in Australia, the Australian legal system and profession may offer an attractive neutral venue for resolution of disputes between Indian companies and companies from other countries other than Australia. So one bears in mind that for many years London or New York have been identified as a neutral forum, now often Singapore and Hong Kong, but Australia is another jurisdiction where, because of the common ties, the common legal tradition, the common skill set, lawyers well versed in international disputes, Australia may provide another attractive neutral forum for international dispute resolution, whether it be as a seat for international arbitration when one is looking for a neutral seat, or indeed when one is looking for a neutral court. For many years, of course, the High Court of Justice in London, the Commercial Court, has provided the seat or the location for the resolution of international disputes. But I would suggest to you there's no reason why one would necessarily choose London these days over a place like Sydney, for example, or Perth, with similar attributes to the British legal system in terms of a well-established set of common law principles, independent courts, transparency and skilled lawyers. Let me tell you a little bit more about the Australian legal profession. Australia has always been a trading nation, and one consequence of that is Australian lawyers are both trained in and familiar with principles of commercial law, particularly relevant to transnational disputes, including principles relating to export and importation of goods, shipping law, international financing, including letters of credit, and principles of private international law or the conflict of laws. Many Australian lawyers also undertake postgraduate legal qualifications and or spend a period of time working overseas, historically most commonly in England, but increasingly in Southeast Asia and in the United States, depending on where they are able to be admitted to practice. But that means that there is a cohort of Australian lawyers, including advocates who claim specialisation in international dispute resolution, and there's been a burgeoning of firms with dedicated international dispute resolution departments. And in that environment also, many recently retired commercial judges and practitioners have become international arbitrators, just as I know from my own experience, many former Supreme Court of India justices go on to have distinguished careers in international arbitration as members of international arbitral panels. And the Australian court system has also been very supportive of international arbitration in the sense that arbitration clauses are broadly construed. The concept of arbitrability has been broadly construed. Restraint is exercised in the scrutiny of the quality of the reasoning process in the awards, and an extremely limited view is taken as to when considerations of public policy will preclude the enforcement of an award. So we have a pro-arbitration bias in Australia, just as there is now a pro-arbitration bias, I think, in many countries throughout the world, including India. a recognition that international arbitration is a very important concomitant of international commerce, and a recognition that it is often the most efficient way to resolve international disputes. So I say, if one is looking for, as Indian companies increasingly will need to do in negotiating transnational contracts or contracts with foreign counterparties, a neutral venue for dispute resolution, one can think more broadly than the typical locations of London, which of course is now, or has always been an extremely expensive venue in which to litigate, but is also shrouded with the uncertainty of Brexit. There was Hong Kong, of course, but that is now shrouded with the difficulties of the current troubles in Hong Kong. What its future as a stable venue for dispute resolution is very much is up in the air. Then one has places like Singapore, which is very competitive for international dispute resolution work, but Australia is on the same time zone and as I've indicated, offers in a legal profession and a legal tradition a venue which may well prove to be as attractive. There's certainly a strong appetite in Australia to provide a neutral forum for international dispute resolution. So I will sum up there. Again, thank you very much for inviting a member of the Australian Judiciary to Delhi for this conference.